While cleaning, fixing, or generally fooling around with a gun, James Hicks discharged a single round through the floor of his North Phoenix, Arizona apartment. As luck would have it, the bullet struck his downstairs neighbor and injured him. The police were called and responded very quickly, seeking the shooter, other victims, firearms, and to just calm the situation down, the officers went to the apartment above to find no one home. It would appear that Mr. Hicks decided that after the accidental discharge of his weapon, or whatever it was, he didn't want to stick around. As expected, the officers were abnormally curious about the goings-on in that apartment, and, not getting an answer to their request to enter, they secured the assistance of the apartment complex manager. Using a master key, the officers opened the door and ventured inside. Fanning out, the officers quickly scanned the apartment. There were no shooters and no additional victims. Of course, there was no James Hicks either. The officers identified and immediately secured 3 weapons, including a sawed-off rifle. They also found a stocking cap mask for good measure. This particular item didn't appear to be all that useful in this North Phoenix neighborhood. The apartment itself was in a dreadful condition. Someone with knowledge of the scene portrayed it as a squalid and otherwise ill-appointed 4-room apartment. I presume this was the description created by Supreme Court Justice Scalia in his majority opinion in Arizona versus Hicks. This did not appear to be a quote from the report written by one of the responding officers. However you slice it, it sounds like James Hicks' apartment was decrepit. I'm sure other words could be used here as well, but here's the point. The officers responded to a certain part of town for a certain kind of incident and found a certain kind of apartment. They reasonably expected difficulty, if not outright trouble. What they didn't expect to find were expensive pieces of stereo equipment stored about the apartment, but they did. Officer Nelson, one of the responding police officers, couldn't help but notice that there were 2 sets of high-end stereo equipment in Hicks' apartment that really seemed out of place. Officer Nelson approached, examined as closely as he could, and decided to pick up and check out one of the pieces of equipment. He spun the piece around and located a serial number. His curiosity still piqued. He called it in to his dispatcher just to see if something showed up. Of course it did. The serial number was listed as part of the haul in a local armed robbery that had recently occurred. Examining the other equipment, Officer Nelson learned other pieces had also been stolen in the same armed robbery. This led to the state of Arizona indicting James Hicks for the robbery, along with an assortment of other charges. So far, so good, but this is where it goes a little sideways. Under the 4th Amendment, every search and seizure must be reasonable. The officers responded to the scene of the shooting and entered the premises to search for the shooter, other victims, and weapons. Up to this point, the officers' actions were reasonable. The officers spread out and searched the apartment for the shooter, victims, and weapons. Also very reasonable. The officers secured the premises. Still reasonable. Now, unrelated to the reason the police were in the apartment in the first place, Officer Nelson made a sharp observation. That expensive stereo equipment sure looked out of place in this abysmal apartment. If he kept his observations to what he could plainly see from where he stood in the apartment, his actions remained reasonable. It's when he picked up the equipment and spun it around to see what he couldn't otherwise see that the court felt Officer Nelson went too far. This new intrusion was unrelated to the purpose that brought Officer Nelson to the apartment, and he couldn't reasonably expect to find the shooter, victims, or more weapons by picking up that equipment and spinning it around. To go further, he needed a new justification. As Justice Scalia stated, taking action unrelated to the objectives of the authorized intrusion, which exposed to view concealed portions of the apartment or its contents, did produce a new invasion of respondents' privacy, unjustified by the exigent circumstances that validated the entry. In other words, he was saying that Officer Nelson went too far. Could Officer Nelson justify this new invasion of James Hicks' privacy? It is, after all, an established fact that the police may seize evidence in plain view without a warrant. But the plain view doctrine is limited to those instances in which the officer has probable cause that the evidence is seizable. In this case, Officer Nelson had reasons to suspect that the equipment was evidence of criminal activity, but he did not have probable cause. Otherwise, he would have known as soon as he saw the equipment that it was going with him to the station house evidence locker. In sum, picking up that stereo equipment without probable cause was unreasonable, and everything learned from that point forward was suppressed from the government's evidence. And the story of the Fourth Amendment continued on. I'm Brian Lemons, and this has been a FLETC Talk.